Hello. Yes. Hi. Hi. Take a seat across there. Yes, African Investments. Welcome. Take a seat over here. Hello. Hi. Please take a seat. Welcome everybody to this mediation today. Before we proceed, I'd like to just clear up the question of language and clarify what would be suitable to everybody. My work language is English, and I feel more comfortable in English. Do you need any interpretation if we go ahead in that way?
Not us.
You're okay? You okay?
No, we're fine.
Okay, thanks very much. All right, my name is Felicity Sigmund, as you know, and what I'd like to do is ask you each to introduce yourselves and at the same time pass around an attendance register so I've got a record of who's here, your position and your contact details. So we can start on that side.
Felicity, my name is Karen Fulton. I'm an administrative clerk with African Investments, and my job entails primarily data capture, and I'm happy to call Karen.
Okay, thanks.
First, my name is Olbaipi. I will be speaking on behalf of Karen. I'm also an administrative clerk for African Investment.
Okay, thanks.
Yeah. Hello, Felicity. I'm Ingrid de Villiers. I'm a manager at African Investments. I'm very comfortable with using Ingrid as well.
All right, thanks.
Felicity, my name is Jerry Kapu. I am a supervisor in the administration department of African Investment. Karen is my ES coordinator, and I'll be happy if you guys want me to check.
Okay. Thanks very much for that. I'd like to check whether all interested parties are present here today, and also to check whether you're fully mandated to negotiate and take decisions in this process. Start a company.
If you give me a moment. Yes. Everybody who needs to be here is here, and we have an open and full mandate to negotiate in these proceedings.
All right, thank you.
From our side as well, everybody who needs to be here is here, and from time to time I'll be taking instructions from Karen insofar as mandate is concerned.
Okay, all right, thank you. All right, just a couple of domestic matters before we get into the issues and into the discussion about the mediation process and the ground rules. Finishing today, I see from the notification that the matter has been set down for the whole day. I'm available at least until 5 and later if necessary. Let me check on your side. Does anyone have any time constraints? Anyone needing to leave earlier? Or can we aim at 5?
Mr. Karpu, Jerry has indicated that if possible, if we could try and finish by 4:30, that would suit the company.
We do not have any time constraints. We can carry on until we finish.
Right. Well, look, let's aim for 4:30 and review the situation when we get there and see how we're doing. About tea and lunch times and other breaks, I'd like to suggest that we take a working lunch. I'm going to tell you a little bit later about the process and how we will spend some time together like this, but we'll also spend a bit of time in side meetings. And I'd like to suggest that in those side meetings, that we use the side meetings to have the lunch break. So when I'm with one party, at around about 12:30, the other party have lunch and vice versa. I'd like to try and limit that lunch also to about half an hour, but again, fit it in with the side meetings. In terms of tea and coffee, the tea and coffee facilities are just outside. And again, I'd like to ask you to take tea and coffee as we go along, perhaps as I leave you and go to the other party rather than take formal breaks. It's helpful to try and limit the interruptions as far as possible, again, so that we maximize the time together. So I'd like to suggest that people turn their cell phones off and try and limit the use of the phone to the breaks or to times when I'm with the other party. That would be very helpful. All right. I have received a little bit of documentation from the company on the dispute, but I don't believe I've received anything from the union. I just wanted to disclose that before we move ahead. I'll come back to that point a little bit later.
Just on that point, will we be given an opportunity to have a look at those documents before those documents are actually discussed?
Well, let me tell you a bit about the process and then at the same time indicate where the documents would fit in. First of all, as a mediation process, it's quite unlike court or arbitration or any of those sorts of processes where someone's going to make a decision. My role here is to help you talk in greater detail about the dispute and to see if we can't find a settlement that is mutually satisfying. It's not for me to advise you, to impose any solution, to try and persuade you to do something that you're not comfortable with, but as I say, to help you find a solution that you are entirely happy with. And in doing that, the way we're going to do that is to spend some time together in a joint meeting like this, and if the company wishes to share that information in the joint caucus, their documentation, they're quite free to do that. But we'll also spend some time in side meetings, and any information conveyed to me in those side meetings, I give you my assurance, is confidential. So if the company chooses to convey those documents in that meeting, to talk about them in that meeting, and wants to restrict them to that meeting, then they're confidential to that meeting. And of course, exactly the same thing would apply to the employee. So I'd like to treat the documents in that way. Is that okay?
That's fine.
All right. Just turning to the actual mediation process, so that I can give you an idea of how we're going to tackle the issues. In a moment, I'm going to ask you to each give me a basic opening statement, explain your story, the background to the dispute, give me an idea of what you're coming to this process with. I'm going to ask that during that time, if, let's say, the company is talking, that the employee representative and the employee remain quiet. If you'd like to raise any points in relation to what they're saying, just make a note of those, and I'll come to you a little bit later. I'd also ask that you don't ask any detailed questions of one another. I'll give you an opportunity to ask questions once both parties have made their full opening statement. And then once we've clarified what the issues are, once we've clarified the issues, we'll then move on to a very detailed understanding or analysis of the dispute. Generally, it's very difficult to find good solutions in a problem situation if you don't fully understand what is in dispute between the parties. So we're going to analyze the dispute very carefully and then turn to looking at options for settlement. We'll spend some time looking at a variety of possible options for settlement, and there the creativity comes in, and suspending judgment and being prepared to consider options you might not have thought of before. We'll then start honing those options down to something that's possible, a possible agreement, and hopefully that will take us into an agreement. There is, of course, the possibility that we won't reach agreement and that there might be a deadlock. In that event, I will give you a minute of the mediation proceedings, and we'll discuss the way forward before you leave. Okay, so that's basically the process I'd like to follow. A couple more points about the process. As I say, my job is to help you reach an agreement, and my task is to focus on the process of negotiation, of problem solving, of finding the solution that you can live with, as opposed to deciding on substance or even getting involved in the substance. So it's really for you to dig deep into your creative side and bring to the table some ideas and some ways of finding a solution. Leave the process to me. In terms of side meetings and staying together, leave that to me. It's very much something that I'm familiar with, to decide when we'll stay together and when we will separate. A couple more guidelines for the process. I've said it's confidential, and I mean it's confidential in those side meetings, but I'd also like to get an indication from you about whether you'd feel comfortable to agree that the process as a whole remain confidential and that neither party resort to the press or any outside source until we have agreed that the process has been exhausted.
Yes.
Company side?
Yes.
We agree.
All right, thank you. All right, the process is also off the record and without prejudice, so that whatever moves, whatever concessions, ideas come onto the table during the process will only be formalized if that's what you're comfortable to do at the end of the process. But will remain ideas, off-the-record ideas, during the course of the process. Both that rule and the confidentiality rule are there in order to relax you, to make you realize, or to give you the opportunity to completely open up to possibilities that might not have come to you before, and to not fear that anything you say you're going to be held to in a way that you might not be comfortable with at the end of the process. So those are two particular guidelines that I wanted to stress. All right, I'm going to be taking rough notes, and those notes are, again, not for any later process, because the discussions are without prejudice, but I also would like to get an indication from you that you agree that I would not be called into any later process to divulge any information or to divulge those notes. The matter might go on to arbitration, it might go on to some other process, and again it's helpful to be assured that I will not be called and my notes will not be used. You comfortable with that?
Yes.
All right. In conducting the process, participating in the process, I'd like to ask you to follow the normal meeting rules, meeting guidelines, and that is to speak through me as the chair rather than to interrupt and to speak to one another directly. So speak through me. And also if we can follow an order of speaking. We're a small meeting, so we don't necessarily have to indicate in a very formal way, but I'd like to ask you to not interrupt one another and just indicate to me that you want to make a point so that we can keep some order in the discussion. All right, any questions before we go ahead?
No, I think that's very clear. Thank you, Felicity.
We don't have any questions, Felicity.
All right. Okay, well, let's turn now to the opening statements, and it doesn't matter who begins, the company or the employees. But let me invite somebody to start, to begin with their opening statement. Who would like to go first?
Well, let me kick off, Felicity, if I may. Look, Corin has been with the company for 10 years and is actually a very good employee, but we've started experiencing a number of problems with absenteeism. The level of absenteeism is rising. We are in a banking environment, and particularly with someone like Corin, who's a data capturer, it's a job that has to be done regularly on a daily basis, and any absence is problematic for us. So that's just by way of background and where we're coming from. And regrettably, we had to terminate Corin's services because she was absent from work last September for a period of 6 days, from the 6th to the 11th of September. She claims that the absence was justified. I'm sure her representative will tell you about a child that was ill, but our difficulty is that we don't have any proof of that. And because absenteeism is such a problem, it obviously sets a precedent, and we have to deal with these things we see these things in a very serious light. Again, because of the nature of the work, we also have put in place a practice whereby employees are required, if they are going to be absent from work, to notify the company. And again, not only was she absent for these 6 days, but she didn't contact us, she didn't contact Jerry here, who is her immediate supervisor. And again, we didn't know what was happening, we didn't know whether we should get a temp and so on. And it really was very disruptive for us. And as I say, the company is very sympathetic to Corin. She's been a very good employee, but we've got to send this has got to stop, and we've got to send a message to the employees about absenteeism. So, as I say, regrettably, we had no alternative but to terminate her services after a proper disciplinary inquiry, of course.
All right, thanks very much. I'll come back to you a little later for clarification. Joel, can I hear the employee's opening statement?
Thank you very much, Felicity. Karen's story is very simple. The employer has just set out that she has been employed with the company for 10 years, and that in that 10 years, she's been a model employee. We agree with the presentation that has been put forward by Ingrid. We obviously differ on the lack of justification for the absence. It is true that we were unable during the disciplinary inquiry to supply the company with proof that Karen's child was sick. But I assure you, Felicity, that this is not just a story. The problem we had was that the doctor who looked after Karen's child and performed the appendix operation would only come to any form of a hearing if she was subpoenaed. So clearly we could not subpoena her to the disciplinary inquiry, and we relied on the evidence of Karen to tell the company of her whereabouts. It is true that there is a problem with absenteeism in the company. I am an employee of that company and I have experienced it. It is, however, regrettable that having had such a trying time with her child, Karen, on the company's version, Karen is to be made an example of. We think that under the circumstances, the company should not be rigid and really judge this matter on its own merit, because we believe there is merit to Karen's absence. I'd just like to check with Karen if she wants me to add anything.
All right, go ahead.
Thank you. I have not covered everything, I realize. The first point is the severity of the crisis that Karen found herself in when the child fell ill. It was an appendix situation, and it had to be attended to there and then. It is due to the stress of the circumstances that Karen failed to notify the company, and it was not a willful neglect on her part. The final point and the disturbing point arose from the disciplinary hearing itself. We have subsequently learned that during the lunch break, the chairperson of the disciplinary inquiry was seen talking to or conferring with the company representative, a situation we find very uncomfortable at this stage.
Okay.
And that concludes our presentation.
All right. Were there any questions of clarity on the employer side?
Just if you'll hold a minute. Yes, I think that we understand what their position is.
All right. And any questions on your side?
We also understand what the position of the company is. We however have only one question, and that is whether they don't believe that Karen had this problem. It does not seem to follow to us to have Karen represented as a loyal employee for 10 years and at the same time not believe her when she says her child had this appendix problem.
Okay, well, I think that really goes to the core of what the issues are in this matter. And let me just try and summarize them, and then I just do have one question. First of all, the question of whether there was justification for Karen's absence. So we need to have a look at that. And then secondly, the question of whether dismissal was the appropriate sanction for the failure to notify. And essentially you're saying dismissal as a consequence is a severe consequence, and you question that. So we need to look at those two issues. Then in relation to the procedure, this last point, there we need to look at the allegation that the chairperson spoke to the employer representative during a lunch break. I'd like to suggest we now break into side meetings, and I think, again, it doesn't matter who I begin with, but I think considering that I did get some documentation from the company beforehand, I'd like to start with the employee representative and with the employee. And what I'm going to do is ask you to step next door to the other mediation room, and then I'm going to come back here and spend some time with you. I'd like to just have a very brief chat with you next door when we get there. But let me just say more generally to both parties that it's always very difficult to tell how long you're going to be during these side meetings. So please be patient. If I'm excessively long, I'll pop back and let you know how long I'm going to be. But don't wander, just stay there and just bear with me. And also don't read anything into the length of time I'm spending with the other party if you're sitting out there waiting. It's enormously helpful to spend whatever time is necessary to explore possibilities in those side meetings. So please bear with me.
Yes.
All right, thank you.